wondered if you can start the trademark process before you've even started your business? Well, you have come to the right spot. Stay tuned because I'm about to explain how to do just that. Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and welcome back to All Up in Your Business. Today, we're going to talk about filing a trademark application with the USPTO on a 1B intent to use basis. I'm going to tell you what it means to do that, when you would want to do that, and the process if you filed an intent to use trademark application. But before we get into it, don't forget to like, subscribe, and share, and check the description for links to additional information and resources, including my Intro to Trademarks guide, which you can download for free, and you can learn more about Brandish, which is my online DIY trademark course that teaches you step-by-step how to prepare for and file a trademark application with the USPTO on your own without a lawyer. All right, so if you're ready to file a trademark application with the USPTO, one of the first steps is selecting your filing basis. The two most common filing bases that we deal with are either 1A current use basis or a 1B intent to use basis. Something I've mentioned plenty of times here on my channel before and in conversation and on social media, and I say it a lot, and I really like to say it because it gets people confused, but it gets my point across. A trademark isn't a trademark until it becomes a trademark. What do I mean by that? You have to actually be using a trademark in commerce in connection with your goods or services in order for it to be considered a trademark. A trademark isn't an idea for a name or an idea for a logo that you want to use for your business. Those are ideas for trademarks, but only when you're actually using it, when the public is seeing it on your website and they can sign up for your services or they can purchase your product. Only when we are seeing it out in public in connection with the sale of your goods or services does it actually become a trademark. And so with that, if you're filing a trademark application, the trademark won't actually be registered if you're not using the trademark in commerce. And that's where that 1B intent to use filing basis comes into play. If we're filing a trademark application on a 1A current use basis, we are telling the USPTO that we are currently using this trademark in commerce. And along with that, we have to attach to our application a specimen, which is basically proof demonstrating to the examining attorney, to the USPTO, how we are using the trademark in commerce. Often this will be a screenshot or a few screenshots of a website. Sometimes it can be product packaging or labels on a product or marketing materials. Specimens can come in all shapes and sizes. But the point is, with a 1A application, we're attaching that specimen when we submit the application. But what if you want to get a head start on the trademark application process? Or what if you're starting your business and you want to make sure this trademark's actually available for you to use and available for you to register before you fully launch? Or what if you're already pretty sure that the name's available, you'll be able to get the trademark, but you want to make sure no one swoops in there before you get around to it and files an application before you do. Those are all perfect instances for filing an application on a 1B intent to use basis. When we file on a 1B basis, we're telling the USPTO we're not currently using this trademark in commerce, but we are intending to in the near future. Technically, we're telling them we have a bona fide intent to use it at some point in the future. But the point is, we're telling them we're not currently using it, but we're planning to. Filing on a 1B basis is a great way to get the USPTO's kind of stamp of approval on your trademark before you invest a ton of money into marketing materials or designing your website or designing your packaging. And before you go investing into this name or this logo that you might really, really love, but maybe it's not available. Filing on a 1B intent to use basis is a good way of making sure through the USPTO's lens that this is going to be available for us. And like I said, it's also a great way of making sure that nobody else gets in there and files an application for the same or a similar name before you start using your trademark and file on a current use basis. Basically, it's like getting your foot in the door, starting that application process and that registration process before you've actually started your business. And then once you've actually started, then the trademark can eventually become registered. So what does the process look like if we're filing on an intent to use basis versus a current use basis? It's not all that different. For the most part, the process is pretty much the same. The first difference you're going to run into is when you're filing the application. Of course, we're not going to submit a specimen along with the application. Since we're not using the trademark yet, we have no specimen to submit. So we leave that out of the application. But once it's submitted, the process immediately after is exactly the same as filing on a 1A current use basis. The USPTO is going to assign an examining attorney to your application, and this examining attorney is going to look over your application, make sure everything's in line with the laws and requirements for registration, and they're also going to do a search and compare your trademark to other registered trademarks with the USPTO to make sure yours isn't confusingly similar with somebody else's registered trademark. If the examining attorney finds any issues with your application, or if they have questions or need clarification about something, or if they run across some confusingly similar registered marks, then the examining attorney is going to issue an office action, which will describe why they need more information or why they're initially rejecting your application if there are other marks that might be too similar. But let's pretend that doesn't happen. Let's pretend everything is correct on your application, no office actions are issued, nothing like that happens. After the examining attorney goes over your application, does their search, they're going to approve it for publication. This is true for both a 1A and a 1B filing basis. It'll be approved for publication in the Trademark Official Gazette and then will be published for 30 days, which gives the general public an opportunity to oppose your registration if they feel that it steps on their rights or might be confusingly similar with their trademark. After publication, this is where things start to get a little different with a 1A versus a 1B application. So if we're filing on a current use 1A basis, after publication, the process is pretty much done. The examining attorney is going to do one more review, a once over after publication, just to double check that everything's okay. But then within a short amount of time, the trademark's typically going to be officially registered. They send you the certificate. We celebrate and have a party, break out the champagne. We're trademark owners. Great day for everyone. But on a 1B intent to use basis, after publication, now's our time to start telling the USPTO we have started using this trademark in commerce. Because like I said, they won't register it unless you're using it in commerce, because it's not a trademark unless you're using it in commerce. So after the publication phase, after all of that stuff, with a 1B intent to use application, the examining attorney is going to issue a notice of allowance. In a nutshell, the notice of allowance will say everything's good with your application, we don't have any issues. Now's your opportunity to file a statement of use or request an extension to file the statement of use. Once that notice of allowance is issued, we have 6 months from the date of that notice of allowance to file a statement of use. The statement of use is basically the specimen. This is where we again show the USPTO proof that we've started using the trademark in commerce in connection with the goods and services that we identified on the application. We have to tell the USPTO the date of first use, along with uploading the specimen, which again can be a screenshot of your website, marketing materials, product packaging, labels, a whole host of different options there. But we'll file that statement of use to show the USPTO we're good to proceed with registration. But what if there's that 6-month time frame after the notice of allowance? What if we haven't started using the trademark yet? What if we need a little bit more time? Don't worry, we can get more time. Instead of filing a statement of use, we can request another 6-month extension to file the statement of use. And we can continue requesting extensions up to 5 total extensions, which overall gives you about 3 years at maximum before you'd have to file that statement of use. The other difference here is going to have to do with filing fees. So with a 1A application, the only fees we usually have to deal with are those initial application filing fees. But with a 1B application, the USPTO is going to charge us a little bit when we file that statement of use or if we request those extensions. Currently, the USPTO filing fee is $100 per class to file the statement of use and $125 per class for each request for an extension. So if we get that notice of allowance, we need a little bit more time, we can request another 6-month extension for $125 per class. We'll get an additional 6 months, maybe we need more time. We can request another extension. Again, another $125 per class. Or if we're good to go, if we're ready, we can file that statement of use along with that filing fee of $100 per class. And then from there, assuming the examining attorney accepts your statement of use, accepts the specimen that you submitted, no other issues arise with the specimen, then the trademark will proceed through the process and will be registered within a few weeks typically after that statement of use. Sometimes though, we might have to get a little creative. Let's say we filed the application and we identified a few different classes of goods and services. Maybe we're selling clothing and apparel, and we're also selling household items like coffee cups, dishes, couches, dog food. Let's say on our application, we told the USPTO we're going to be using this trademark in connection with the sale of clothing and dog food. So that notice of allowance, we get that, and we've got 6 months to file our statement of use. But what if okay, we've started selling the clothing, but we still need more time with the dog food thing. We haven't started using our trademark in connection with dog food just yet. Can you request an extension for one and file a statement of use for the other? No, but there is a way around it. And this is by using a request to divide. A request to divide is kind of exactly what it sounds like. We're requesting that the USPTO divide our application into 2 or more kind of child applications. So instead of having one application with 2 classes of goods and services on it, we're dividing it into 2 separate applications, each with its own class of goods or services. Now we can file the statement of use for the clothing items on that application, and we can request an extension for the dog food on the other application. And the benefit of this is that it won't hold up the registration because we can't show use of both classes. Otherwise, if we requested extensions for each, that's going to delay the registration until we're using the trademark for both classes. That's not always a terrible thing, but sometimes we want to get that registration done right away, or as soon as possible at least. So by requesting to divide the application, it lets the registration go through with one class and will keep the application kind of in this pending phase for the other class or classes. And there is, of course, an additional filing fee for submitting that request to divide, because technically we're now creating a brand new trademark application, so the USPTO wants some extra money for that. Currently, the filing fee for a request to divide is $100 per class in most instances. Whether you file the statement of use or request an extension to file the statement of use or request to divide applications, outside of that, the rest of the process is going to look pretty much the same as if we're filing on a 1A current use basis. Once they get that statement of use and review the specimen, make sure everything looks good, the last step is that one last review, and then it will be approved for registration. Then yay, registration, party, champagne, certificate, all the good stuff. Or in some cases, we can request extension after extension, but they only give us 5 requests. Sometimes we need more time than that, and in those instances, typically the application will become abandoned if you don't eventually file a statement of use within that time period after we've maxed out all of our extension requests. So if you're thinking about filing on an intent to use basis, you want to make sure you've got a pretty decent opportunity to actually launch your business and start using the trademark within, at a maximum, about 3 years, which is a pretty good amount of time. On the shorter end, after we file the application, we'll have about 9 months, give or take. Sometimes it's a little bit longer, sometimes a little bit less, but we'll have about 9 months after we submit the application before that notice of allowance will be issued, and we'll have to file a statement of use or request an extension. So as long as you feel pretty confident that you can launch your business, start using the trademark within about 9 months to 3 years after you submit the application, then an intent to use filing basis is a great way to make sure the trademark's going to be available for you before you've fully launched or before you've invested a ton of money into your branding and business and getting the name or your logo or your trademark or whatever it is out there. That's all for this episode, folks. Drop a comment below. Let me know what you think. And again, don't forget to check the description for links to additional information and resources. You can download my free Introduction to Trademarks guide for a better overall understanding of how trademarks work and why a trademark isn't a trademark until it becomes a trademark. Or if you're interested in submitting a trademark application with the USPTO and you can't afford to work with an attorney, or maybe you just don't want to work with an attorney, but you need a little extra hand-holding, then check out Brandish, my DIY trademark course where I teach you step-by-step how to prepare for and submit a trademark application, whether on a 1A or 1B filing basis. And I walk you through the entire process so you can take care of your own trademark registrations without a lawyer. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.